Thank you, Mr. Speaker, and it's extremely pleasing to be able to speak on the third reading of this piece of legislation, third reading which has been a long time coming, and I'm sure all members of the House will be pleased when this piece of legislation is finally passed into law. The Minister said in his third reading speech that this piece of law is all about balance, and he's absolutely right, but with the greatest of respect, I don't believe he has that balance quite right. There is absolutely no doubt that the law that we are passing here in this House today, or whenever it finally ends up being passed, is far better than the status quo, and Labor of course will be supporting it for that reason. But the Minister had the opportunity to make the lives of the hundreds of thousands of tenants in New Zealand a lot easier by a few simple amendments, and I am very disappointed that he chose not to do that. People who rent their properties don't have security of tenancy. It's not like owning your own home where you know that you're in it, that no one can make you leave it with 90 days notice. And they face enormous pressures now. Rents are going up. I had a letter from a Housing New Zealand tenant today. Well, you know, someone on the average wage under the National Party's tax cuts is going to get, on a minimum wage, will get $3 a week. Guess how much her Housing New Zealand rent is going up? $3 a week. That's not even including inflation. So when you factor inflation in, she is far, far, far worse off. But even if you pretended that inflation didn't exist and the GST increase didn't exist, her tax cut of $3 has already been swallowed up by a $3 increase in her Housing New Zealand rent, and she is worried. And it may seem like a small amount of money, but that's what we're talking about. With the 30% of New Zealanders who rent, the overwhelming majority of whom have a combined household income of less than $50,000. These are people that the government should be protecting, not taking protections away from, as that minister did when he amended the piece of legislation that Labor put in place. The minister mentioned boarding house tenants, and he's quite right when he says that it is incredibly important that they come under the protection of residential tenancy law. But Minister, the job isn't done. Because it's all very well to say that yes, now they have the protection that someone can only evict them on 28 days' notice instead of 24 hours' notice. But the state of these boarding houses, they are filthy. They are disgusting in many cases. I went and spoke to one of the councils here in Wellington who told me that because of the 1991 Building Act changes, prior to those changes that his previous government put through, councils were responsible for boarding houses. They had to know where they were. They could go in and check them because they were multi-resident dwellings. They could make sure that they were in a state fit to be lived in. That was taken away from them with those 1991 changes. The Minister may not know that. I didn't know it until they told me that. But the fact is that a lot of councils don't know where these places are. They are disgusting. A number of them don't have running water. And unless someone points this out to the council, and the tenants aren't going to do it. These are incredibly vulnerable people who don't know that they can just go to the council if they don't have running water. And it wasn't until the Wellington Central MP Grant Robertson actually pointed this out to the Wellington City Council that they said, thank you very much, Mr Robertson. We are going to go in now that we know it's there. We are going to make sure that, given the limited public health role that we have, that we are going to make sure that that's fixed. And now we know it's there, we're going to be able to keep an eye on it. But it shouldn't have to be like that. It shouldn't have to be that some of our most vulnerable citizens rely on the Coalition to End Homelessness taking MPs around to show them the parlous state of boarding houses for action to be taken. So the journey for boarding houses and reform in that area has only just begun, Minister, and Labor will be more than happy to assist you on that particular journey. I want to come to the SOPs that were voted down in the committee stage, unfortunately. When we talk about boarding house tenants, the Minister alluded to the fact that over the Wellington Sevens, boarding house tenants were evicted en masse. I put up an SOP in the committee stage which would have made that illegal and said that for a major event it's not okay to evict boarding house tenants or indeed any other family from their home for the purpose of making a quick buck over a major event like the Rugby World Cup. This is a serious issue. The Minister chose not to deal with it. He doesn't think it's serious enough. He thinks it's okay that someone can be told, we're going to give you a 90-day notice. Because the point, Minister, is, yes, now boarding house tenants will have to be given 28 days notice of eviction. But landlords have had more than 28 days notice of the Rugby World Cup. They have told their boarding house tenants already, you will have to get out over the Rugby World Cup. Private sector rental tenants have been told, you will be issued a 90-day notice and have to get out over the Rugby World Cup. And I am shocked that this Minister of Housing thinks that that's okay, thinks that that should be allowed to happen. I'm actually very, very disappointed in him in that regard. when it comes to the issue of letting fees, it is hard enough for tenants to get into housing nowadays without the government putting up more and more hurdles in front of them. Labor thinks it's only fair that if a landlord wants to hire a property management organisation to market their property, that they pay for it, not the tenant. Apparently the national government doesn't think that that's the case. When it comes to the issue of the Tenancy Tribunal, I acknowledge that in all those situations, theoretically, you can get representation. Minister, go and talk to the tenancy advocacy groups who will tell you it is not happening. It is not happening. People are being denied representation in the Tenancy Tribunal. It seemed to me simple to say, well, across the board, we're just going to say that you can have representation because we know that in many cases it actually expedites the process. It stops tenants being vexatious when they feel they don't get in their own way, when they start to panic that they don't know the points of law, they don't necessarily know their rights. But more than that, the Tenancy Tribunal actually has the power to remove people who are being vexatious. So if he's worried that a tenant advocate is going to go in and start to try and drag out the process or slow it down, the Tenancy Tribunal is, and he didn't mention that they have this power because it didn't suit his argument, the Tenancy Tribunal is able to say, I'm sorry, but we're going to remove you because we feel that you are not conducive to this process, which, as he says, I completely agree as well, is meant to be fast and meant to be cheap. So, in fact, the situation he outlined, where tenants have all these rights to have representation, sounds good. But, Minister, it is not happening. It is not happening. And very, very vulnerable people are being denied representation at the Tenancy Tribunal. Well, I would hope he does care. I would hope he does care, and I hope this isn't just an exercise in saving face and not wanting to vote for a Labour Party SOP. On the issue of the amount, $6,000 is a lot of money to a boarding house tenant. To say that they have to be able to meet the threshold of the monetary claim being worth $6,000 more is ridiculous. They are never going to get there. That's la-la land stuff for some of the most vulnerable tenants that we're talking about. It's extremely disappointing the government's lifting the threshold from the current level of $3,000 to $6,000. Even more disappointing that they weren't prepared to remove that threshold altogether and make sure that the Tenancy Tribunal is a fair forum for everyone, including those who are not familiar with that process or not able to adequately represent themselves. When it comes to the issue of cleansing orders, the most astonishing thing about this was I was arguing to put back in a clause that the Minister himself put in. I mean, this was Minister Heatley's clause in the Residential Tenancies Amendment Bill, and I've never heard such an eloquent destruction of a minister's own clause before. He got up as though he'd never seen this before and failed to mention that he put that clause into the legislation. At some point in history, Minister Heatley thought that it was important enough that tenants be told about methamphetamine labs and whether cleansing orders had been put on properties or not. And I don't know who got to him in the meantime. The Select Committee made a decision that we would take that out. Subsequent to that, it was a rushed decision because the Select Committee was rushed. Subsequent to that, I have seen overwhelming evidence that, in fact, it is not as clear-cut as the Minister made out. In fact, the practices across councils are not uniform. They are not policed. They are not at the level that the Minister seems to think that they are. And what the Minister also failed to address was how is a tenant going to afford $350 for a limb in order to find out whether or not there might be a cleansing order that they have no idea is there or not. So just on a whim, a tenant who's also had to pay a letting fee because he thinks that they should have to, has also had to pay a bond, has also had to move all their stuff, is now going to go to the council because they're worried it might be a methamphetamine lab and say, you know what, I'm just going to chuck $300 at you on the off chance that there was a cleansing order on this property for a methamphetamine lab. All we said was you just have to tell the tenant that this happened and show them that it's been cleaned up. More than that, I improved the Minister's clause. I spoke to the property investors and said to them, how do you feel about this? They said would rather that you stuck with what the Select Committee did. But at Select Committee we did say a 5-year time limit would be fine. We just don't think you should have to tell people forever. And we think that 5 years would be a fair time limit to say if it's been in the last 5 years, you just have to tell them. I mean, it saves everyone money. It means a tenant doesn't have to fork out hundreds of dollars for a limb which they might not even need. And let's be honest, in this tight housing market, how many tenants are going to say, you know what, it's really hard to get a property at the moment. I finally found a place that I can afford. Just hold on while I go and wait however many days it takes to get a limb and find the money to pay for it. It's astonishing that the Minister voted against his own original amendment to this piece of legislation. Mr Speaker, This is a very good piece of legislation overall. It's not as good as the one we put up. It's a shame the government has watered it down. This is a missed opportunity.